that it should look at before allowing or disallowing such an application. At paragraph 24, Your Honor, what is important is the insistence, Your Honor, at paragraph 24, is the insistence that this application must be made in good faith. And it must be demonstrated while at it that there are exceptional circumstances to warrant the continued pre-charge detention over the respondent. And secondly, Your Honor, on the second limb, that, Your Honor, we do not have any other less restrictive measure that the court can employ in balancing the quadruple rights that are at play at this time.
Less restrictive measures.
Yes,
measures
yes.
to be employed by the court.
Yes, Your Honor. Because it's in essence an invitation to limit the right of the respondent. Your Honor, just to apply on these circumstances, very briefly, and I close.
You've said very briefly like 3 times.
Yes. Your Honor, the insisted mention, the mention that the respondent is a flight risk has not been corroborated by Mr. Corporal Kennedy Murunga. He hopes that with his word alone, that the court will grant the 14 days, deny the respondent his right and freedom, and the wife the comfort of having his husband at home. There is nothing whatsoever in the briefly drafted supporting affidavit by Mr. Murunga that demonstrates a cogent reason why this court should sanction the pre-charge detention of 14 days, Your Honor, for a complaint that is a misdemeanor under law. I urge with respect that on the strength of the Oscar Sudi Kipchumba decision, that you find the application lacking merit. For the balance and the comfort of Mr. Murunga, the court can be pleased at this juncture to grant reasonable bail or bond terms to secure the release of the respondent, and to set any terms which the respondent has been advised to respect pending the decision to charge the respondent. Your Honor, I had so many other authorities, but
Maybe you give me, I read them in my free time.
Yes.
But for now, I'm telling you, I'm not going to read them.
Yes. But Your Honor, I think we have just summarized everything to demonstrate that Mr. Murunga should find other convincing reasons.
Okay.
Thank you.
Prosecution, you want to reply?
Just briefly, and I'll just rely on the authority that has been used by the defense. Refer
The authority is
should be case number 19 of 2024.
Sudi Oscar.
No, too late.
Number you've given 2.
Yes.
You said Sudi, and which other one?
Sudi, the other one is Michael Rotich.
Michael Rotich is in Sudi.
Yes.
Yeah.
Wait, paragraph 21. This one. Let me assist him. This one.
It has been demonstrated that the accused person works in the place where the good IO intends to go and investigate. And the defense has stated that.
Wait.
Sorry.
The defense?
Defense has actually confirmed that he works for the National Police Service. That is a position of authority that the suspect holds. And being that this is the likely institution that he intends to go and investigate, as the court to look at paragraph 22 in their supporting case. To be precise, paragraph number.
Paragraph 22, yes.
Yes, where it indicates that the likelihood of the accused person interfering with witnesses or may suppress any evidence that may incriminate him, that he works for that particular organization. Of course, he's familiar with persons who are there, and being that he holds a position of power, the court should take that into consideration.
Okay, I find in my ruling, the ruling that I'm delivering, I find that there is merit to the application that has been made by the IO to hold the respondent for 14 days. Though the crime that is being investigated is a misdemeanor, it opens up something more serious than just a misdemeanor, but that the fact that people are given firearm certificates without the authority of the Firearm Licensing Board. This court also has a duty, however, to look at the right of the respondent, a right which is given by the Constitution under Article 49(1). I'll also rely on the case of Michael Rotich versus Republic 2016 EKR. The Lord Justice Kimaru stated that it was unconstitutional to ask to extend time to detain a person without a holding charge. He went on to state that a holding charge would enable the respondent to know the offense and the reason for his arrest. He also said that, of course, he said it was illegal for the prosecution to seek to continue holding the respondent without a holding charge. But he also said that it will not do for the prosecution to present a person who has been arrested in court and seek his continued detention without a charge or holding charge being lodged in court. If this trend continues, it will erode all the gains made in the advancement of human rights and fundamental freedoms as provided by the Bill of Rights since the 2010 Constitution was promulgated. The respondent is clearly not a flight risk from what has been said. And contrary to what initially the IO said during his in chief, the IO does know where the respondent lives. Remember, you had said you don't know where he lives, but during cross-examination, you went on to state that you knew where he lives. So you know where he lives, you know where he works. And I think the greatest fear for the investigation, or rather what you fear is going to happen, is that the respondent might inform the other culprits, and then they will either take off or maybe clean up their act. But if I'm looking from outside in, I'm seeing like as if the crime is in-house. The crime is in-house. So the people you're investigating are still working. I find that it is only fair that I give him bond terms, and then I'll give the terms. So I hereby grant the respondent a bond on the following terms: that the respondent may be released on a bond of 500,000 with a surety, or a cash bail of 200,000 shillings with one contact person. Then these are the other terms for the respondent: that he should not make contact with any of his colleagues at the Firearm Licensing Board, because now everyone there is a suspect. Then you should attend to the investigating officer anytime you're called to the station to help in the investigations. failure to which the bond terms are going to lapse. Sawa? Yeah, so we'll mention this matter in 14 days. So
15th
mention.
October.
When?
15th October.
So 15th of October, 2025. It will also give you more time to investigate.